I think we are going to go ahead and start the afternoon session so we can keep our somewhat amazing track record of staying on time for this hearing. So thank you to OPP and the FTC staff for having kept us on track. I'm Andrew Stivers. I'm the Deputy Director for Consumer Protection in the Bureau of Economics, which just means that I'm basically in charge of the Consumer Protection Economics mission at the FTC, and I'm delighted to basically just introduce a series of really good speakers this afternoon. So I'm going to step out of the way, and we are going to start with Liad Wagman, who is a professor at the Illinois Institute of Technology and Stewart School of Business. Liad.
Thanks. Thank you again for having me here today. This is joint work that is fresh off the copy machine, pretty much, with Ginger Jin and Jian Jia. And we've been in a mad dash to complete it over the last several weeks. Basically, we looked at GDPR and we asked ourselves, where would we notice an impact right away? And the answer we came back with is that investors are likely to internalize the effects. So we thought the law was passed a couple of years ago, back in 2016. Maybe we should notice an effect then because investors would form expectations. The thing is, not much was seen, and we were wondering why. Looking through the news events, we saw that as recently as early this year, more than half of mobile applications are not GDPR ready. And announcements very close to the implementation date, to the enforceability date of May 25th, kept pouring in. The top firms, top platforms started releasing their rules. Apple removes apps that share location data without consent, updates their privacy terms. Facebook says that businesses may want to implement code that creates a banner and requires affirmative consent. Each company is responsible for ensuring their own compliance. You're all on your own. Shopify updates its app permissions for merchants developers. They need to implement them. Google releases consent SDK for developers, these software development kits, just a day before, 11th hour before the enforceability date. And then GDPR takes effect. Okay, so, we kind of understood this all came into this implementation stage of the regulation. And so the effect should be noticeable after that, or as this was happening. So this is sort of a motivation. GDPR has a massive overhaul of data regulation in the European Union and anyone who services the European Union. And that includes data management, auditing and classification, data risk identification, data risk mitigation, interfaces for users to obtain their own data, to provide opt-in consent, and to request deletion of their personal data. Firms are required to train hire qualified staff, or they face severe penalties that are up to 4% of their annual global revenue. Yeah. Bloomberg shortly after said 500 biggest corporations are on track to spend a total of $7.8 billion to comply. Okay, now based on earlier work, we already knew that compliance costs are not incurred equally by firms. Smaller firms tend to take a bigger burden, at least in relative terms. And the other effects we know from theoretical work is that compliance costs will shift some of the innovation activity from smaller firms into the bigger firms. And the reason, especially for tech, that this happens is because larger firms already have the infrastructure in place for R&D. They have the infrastructure in place for internal innovation. And so when entrepreneurs decide to pursue an idea, they have the option of pursuing it internally or pursuing it as a startup, externally, as a venture. Okay, and when they face that choice, they look at the costs. And when the costs of pursuing it on your own increase, your incentive to stay inside and either innovate or not increase. And so the overall, at least theoretical effect, is that innovation is reduced and more innovation happens inside bigger firms. So the bottom line for us was, who's better to assess what really happens than the actual investors who are putting their money where their mouths are? Yeah, they're actually investing in those firms. And so once these policies were rolled out, we figured compliance costs are going to be realized, especially for the smaller ventures, because they rely on the larger platforms' policies for compliance, for who bears the liability for violation, and so forth. Okay, so that's the general idea. Now, we wanted to get comprehensive venture data. It's impossible to get it all in one place, but one of the main databases for venture data that's not a complete universe, but it's pretty good, is Crunchbase. And so we collected venture data from Crunchbase from last summer, July 2017, until the end of September this year. Okay, so it's really, really recent. This data comprises firm information, the firm location, the category it operates in, its founding date, the dates on which it raised money, and a range, a lower bound and an upper bound on the number of employees it has. Think 1 to 10, 11 to 50, 51 to 100, something like that. Okay? Now, it also comprises information about each individual financing deal. That includes the size and the date of the deal, which stage, was it a seed deal, a Series A, and so forth, which investors participated, okay, and the dollar amount, obviously, of the deal. So just to give you an idea for what the data looks like and to convince you that it's good data, I created some pictures to kind of summarize it. So these first 4 pictures show the average number of deals per week in the US and the EU. You can see that the US has a larger number, a factor of 2 or so. The median dollar amount in millions raised per deal, it's about $1.5 million for the EU and $3 million for the US. You can see the average firm age is more or less similar. And the average number of investors that participate in a deal is somewhat higher in the US. Okay? If we look at the composition of firm ages in our sample, you'll notice that about half of them are the very youngest, the 0 to 3 years old ventures. Okay? And the rest are distributed more or less similarly between the US and the EU. So if we dig deeper into these age groups, you can see that the average amount raised per deal is growing the older the firm is. So the youngest group raised the least. They mostly participate in seed rounds and Series A, Series B rounds, and then it grows from there. Okay, and these are averages. They're not medians, so the amounts are a little higher. All right. Now, if we look at the total number of deals, most of the deals happen for those young firms. Okay, they have smaller deals, but they have a lot more of them. And we're talking thousands of deals in just 1 year of data, a little over a year. Okay. And if we look at the median amounts raised per deal, you'll notice that, again, they grow in the firm's age. And this is kind of indicative that the distribution of those amounts is skewed. The median is smaller than the average. Okay. All right. So if we want to dig deeper into the types of deals that are happening, I hope I've convinced you by now that this data is pretty granular, but it goes further than that. You'll see that for those youngest firms, those 0 to 3-year-old firms, most of the deals happen on this large circle, which is the seed round. Those are the smallest, basically, rounds that mainly comprise angel investors and amounts of a few $100,000 a deal. And then it goes from there. It goes to Series A, Series bridge rounds A, B, and other. So on the horizontal axis here, you have the firm age. On the vertical axis, you have the average dollar amount for deals of that type. And then the larger the circle, the more deals we see. Okay? As we move to older firms, you'll notice that the bubbles start floating up as the deal amounts increase, and there are fewer deals, so the bubbles get smaller. And we could go to the older group, and they keep floating up. The age obviously increases. The bubbles get smaller. And we could go to the oldest group, and they keep floating up. Okay? So in terms of where those deals are happening, this is a heat map of US states and the EU member states. We include Britain in the EU because it's still part of the EU as of the time of GDPR's rollout. The EU firms are affected by GDPR just as much. In fact, the UK adopted its own GDPR-like law. You'll see most of the deals happen in California, happen in the UK. In terms of the dollar amounts that go in, it's a pretty similar situation. Most of the dollar amounts go to the UK and California, and Germany picks up some investment dollars as well. Okay? So our observation level here is divided into a state, where a state is either a member state in the EU or a state in the US. Okay? So we look, at least at the aggregate level, at states. Okay? And in terms of time, we look at weeks, investment per week, per state, per technology category. And I'll talk about categories in a second. At the deal level, we look at individual deals. All right? So I hope this was convincing, at least in terms of the granularity of the data we have. Let me give you some idea of the trends here. This is for the number of deals per week, comparing the EU and the US. Okay, the US is the red line, EU is the blue line. You notice that they track each other pretty closely. It seems to be a common trend, and GDPR takes effect in late May this year, and there seems to be some change going on. Okay, now you might argue, oh, this is the European summer vacation happening right after GDPR takes effect, but we don't see a similar thing in the summer of 2017. All right. And we dig deeper into the deal per week, per state, per technology category level. You'll notice that this gap becomes easier to spot. This gap that happens between the red line representing the US trend and the blue line representing the EU trend. And there's a drop that happens after GDPR takes hold. Okay? We could look at variations of this, of the dollar, for example, raised per week, and see the same thing. Okay? We could go further and look at the dollar raised per week, per state, per technology category, and again, we can see the same thing. All right? And we could look at the dollar amount raised per deal. Yeah? And again, we see something similar taking shape. All right? So our next objective here is to quantify this effect, to look empirically at what's going on. And our methodology is what's called difference in difference. So what we do is we find the difference in the US from the pre-period before May 2018 and the post-period after May 25th, 2018. And we do the same thing for the EU, and then we take the difference of the differences. Okay? So we have a couple of specifications, at least at the aggregate level. We use Tobit for the dollar amount, the total dollar amount raised per week per state, and we use Poisson for the number of deals per week per state. We use macroeconomic controls like unemployment, consumer price index, interest rate, GDP. We even included exchange rate. It didn't change anything. And a specification is what you'd expect. We're just looking for the effect of the rollout of GDPR. We use time and state, county fixed effects, country fixed effects, sorry, for the EU. And at the deal level, we use a log linear specification because of these outliers that we have, where we see the average is much larger than the median, and this helps control for that. Yeah, at the deal level, we also include the deal-specific controls, like the age of the firm, the funding stage of the deal, the technology category, things like that. Now, in terms of technology category, we break it down into two categories. One is healthcare and finance, and the other is everything else. The reason we focus on healthcare and finance is because the US has existing laws in those sectors, specifically the Gramm-Leach-Bliley Act, GLB for finance, and HIPAA for healthcare. Yeah? And so we would expect maybe to see something different about that category, that grouping of healthcare and finance. Yeah? The other reason we divide it into these categories is because it creates a balanced sample in the sense that every state has some activity in those categories. So in terms of results, we see an effect on the dollar amount raised per week per member state per category that is substantial. Across all EU ventures, that dollar effect is $3.38 million per week per state per category. And for 0 to 3-year-old ventures, the effect is almost $1 million. Okay. Now, in terms of the number of deals, we see a significant drop of about 17% for the number of deals per week per category per state. The figure presents the average amount, just to make it easier to kind of relate to. And we see a similar drop for those youngest ventures, those 0 to 3-year-old ventures. What this means is that those firms have less of a chance to secure a successful deal which could mean that fewer of them come to fruition. Okay, and in terms of the dollar amount per deal, that also drops. Right? Those drops are pretty significant in the overall sense because some of the later deals are very sporadic. Okay, when we zoom in on those 0 to 3-year-old ventures, the drop there is 27%. Okay. Overall, we see two effects here. We see an effect at the extensive margin in terms of fewer deals taking shape after GDPR takes hold, and at the intensive margin in terms of fewer dollars invested per average deal. Let's talk about some of these categories more specifically. So in terms of healthcare and finance, we see a similar drop in the number of deals of 18.8%. We see a drop in the aggregate amount raised per week per state of $5 million. The average amount invested per week is $30 million. And we see a huge drop in the amount invested per deal, on average. Now, interestingly enough, we see similar changes for all other categories. Okay, we don't get a significant effect on the aggregate dollar amount invested per week because it's, that pool of categories is just too widely spread. It's too broad. So we're not able to identify that effect, but otherwise it's somewhat similar. Okay, and this is surprising because you would think that healthcare and finance would be different since the US has existing laws. What we get out of it is that maybe GDPR is really transformative in the overall sense. Across categories. It doesn't matter if there are existing laws, those laws are old. They're outdated. There's systems in place already to handle those laws, whereas GDPR is new, is fresh, needs new systems, new compliance costs. Okay? Now, zooming back into those 0 to 3-year-old ventures, those nascent ventures, those startups, the effect there is pronounced. Okay, there's 19% fewer deals happening. There's a decrease in the aggregate dollar amount invested per week. And there's a drop in the dollar amount invested per deal on average. Yeah, that's, to me, concerning. And at the same time, we don't know if it's a short-term effect or whether it's going to last. Right? We only have 4 months of post-GDPR data. So that's something to keep in mind. This is at least the short-term that we observe, short-term effect that we observe. So in terms of robustness, we looked at the pre-periods before May 25th. And at least at the deal level, number of deals, we didn't see an effect before May. At the total dollar amount raised per week, we do see an effect that starts a little bit earlier. It starts in April, or late April. So kind of crossing over to May, we see it kicking in early May, really kicking in. Okay, so firms were reacting. They were reacting to those announcements. So as a robustness, we exclude May from our sample, and all of the results still go through. As an additional robustness, we exclude the period between summer 2017 and summer 2018 to control for seasonality, and the results still go through. We top-code observations to reduce the influence of outliers, of those huge deals, and the results still go through. Okay? We categorize industries in an unsupervised manner using techniques like k-means or other machine learning techniques, and the results still go through. Okay? And we used other specifications, and the results still go through. So we tried to break the results, and they don't break easily. All right, so what can we do with this? Well, our data set, as I mentioned earlier, has some information about employment numbers, employment ranges, how many employees are employed per firm. And obviously, we see these dollar amounts decrease in deals, but what does it say about welfare? It doesn't say much. We cannot draw a welfare implication for this. It could very well be that those less desirable firms are not coming to fruition. We're preventing the next Cambridge Analytica. Who knows, right? But we can look at the effect on jobs. So to do that, we got an average for the dollar amount raised per employee by 0 to 3-year-old firms. Okay, and that range is from $123,000 to $1 million. Okay, and we can use this range to see how many jobs are lost because of the less dollars that come into those firms, the fewer dollars that come in terms of the number of investment deals and the dollars per deal. And just if you're curious, how many dollars are raised on average for a broader swath of firms, say 0 to 6-year-old firms, you see that those dollars shrink. And the reason they shrink potentially is because those firms have outside revenue sources. I mean, they have their own revenue sources perhaps, right? So those 0 to 3-year-old firms are the most susceptible to job losses. Okay? They depend on that money in order to hire those people. They depend on those deals coming through in order to operate. So in terms of jobs lost by those firms, based on our back of the envelope, these rough estimates, we see that it's between 3,600 and 30,000 jobs. And that amounts to about 4 to 11% of the number of employees they employ in our sample. Okay? I want to emphasize that this is the effect we see in the short term. We don't know what's going to happen in the long term. Okay? And it could very well be that investors are just pulling out and saying, I want to see how this is going to shake up. And I'll come back later. Okay? It could also be that investors are shifting their dollars to the US, in which case our results may be overstated. Okay? It could also be that there are investors outside the EU that tend to invest in EU firms that hold their dollars back. We don't see them in our sample because we only focus on the EU and the US. And so maybe our results are understated. And the other thing to keep in mind is that these jobs lost are just technology jobs in those 0 to 3-year-old ventures, at least these rough estimates. There could be more jobs lost. There could be jobs lost by firms that are older. There could be jobs lost by people who would have acted in service positions for these jobs, providing lunch, providing childcare, and so forth. So just to kind of summarize what we see so far, is that in the short run, we notice a pronounced negative effect on EU venture financing, both on the number of deals and the dollar amount per deal. Okay? Now, our sample of post-GDPR is relatively short, so more study is definitely needed here. And the reason that investors are holding money back is not crystal clear. It could be a wait-and-see approach. It could be that they're afraid about rising compliance costs. It could be that this regulation is hindering the actual business practices that they want to invest in or the products they want to invest in. Okay? It could just be uncertainty. All right? The other thing to keep in mind is that our sample is a small part of the bigger picture. We don't have a complete universe. We think it's a pretty good sample, but there could, of course, be more. The other thing we notice here is that GDPR is very transformative. It applies across categories, even those categories we would expect maybe less of an effect because of existing laws like HIPAA. Okay? So just one difference between HIPAA and GDPR, one of many, is that HIPAA might require you to provide consent in order to receive service from a healthcare professional, whereas GDPR requires the firm to provide service even if you do not give consent. Okay? In terms of Gramm-Leach-Bliley in financial markets, that regulation provides an opt-out approach. Basically allows customers to opt out of having their data, say, sold to affiliates. And even that's in special circumstances. Whereas GDPR requires an opt-in approach. You have to provide opt-in consent for your data to be used, for your data to be sold. The penalties are also very different. GDPR has much larger penalties, potentially 4% of global revenues. All right? So aside from the negative effects we see on the number of deals, we also have some conclusions, or at least preliminary conclusions for job losses. And again, it's a rough calculation. And other than that, happy to take some questions.
Great. Thank you, Leo. So first of all, I would like to say to all of you, hopefully a number of you are researchers in this area, this is the kind of work that's incredibly valuable, both to the FTC and to our sister agencies working in this area, in terms of really trying to understand what the potential effects might be of changing regulation, changing enforcement in this area. So if you're in this field, I strongly encourage you to there we go. I thought I had got the button. I guess I hadn't. But I hopefully you heard me that I strongly encourage you to do research in this area. I know that a couple of you have some very interesting work coming forward in this area, so we're all eagerly awaiting that. However, since Liad is here, I get to grill him a little bit. I wonder a little bit about the time period that you're looking at You look at the time in which GDPR was actually, the enforcement happened. Did you think about looking at the April 2016 shift, right? Because you'd expect that investors maybe would be, I mean, this wasn't a surprise that it was coming, even though I think you point out that perhaps some of the companies were kind of last minute in terms of getting their compliance up and running. So can you talk a little bit about why you wouldn't necessarily see most of the effect happening right around April 2016, before and after, and then what are you actually measuring? Are you measuring the entire effect of GDPR when you look at the May 2018 date, or is there something a little more subtle about what you're measuring there in terms of the effect?
So first I'd like to say that I think both time dates are meaningful, right? April 2016 is when GDPR passed, right? Came into law, but it wasn't to kick in until 2 years later. Now, the second time period is meaningful because that's the actual implementation stage. A lot of these smaller firms that we focus on, they depend on the policies that are adopted by the larger firms. And those policies were not announced, or not adopted, until the very few weeks, if not the week off, May 25th, 2018. Okay, so a lot of the realization of those increased compliance costs, those increased liability costs, the actual code that you needed to put in your app in order to be compliant with the App Store where your app is published was not available until those few weeks preceding May 2018, at least for the most part. Just to give an extreme example, Google released some code the day before. Now, we looked at April 2016. In fact, we started with that. And just our early checks did not reveal a significant effect. It could be just lack of clarity about what was going to happen. Now, we saw that lack of clarity from regulators as well. If you look at their own models for kind of trying to predict what would happen after the regulation, they had their own uncertainties. Okay? And those uncertainties, I believe, are still not clear until several probably lawsuits settle down. We will not know the full effect.
Okay, thank you very much, Liad. If you can thank our speaker. Thank you. All right, we are going to move to a recorded presentation from Katherine Tucker of MIT. And as soon as we move forward in the slides, it's going to start, which is why we still have Liad's last slide up here. So I don't think I have a card for her. Okay, so I'm going to remove that. Good. All right.
Good afternoon. My name is Katherine Tucker, and I'm a professor at the MIT Sloan School of Management. And today I'm going to be presenting some research I have into the surprising failure of big data in an online advertising world. Before I start, I have two apologies. The first and most obvious is that I apologize very much for not being at the hearings in person. I have teaching scheduled on every single day of the hearings from morning to afternoon, and I'm very sorry not to be with you. It looks like an amazing program. The second apology is, unlike many of the presentations you're going to see over these 3 days, I'm going to be presenting a research paper today. And the nature of a research paper, of course, especially an empirical one like this, is it tends to go after a very narrow set of findings, but make sure that we really believe in those narrow set of findings. But the second apology is that what you're going to hear is about a very specific set of experiments in a very specific context. So, having said that, perhaps we should actually move to the context. And as I alluded to, this paper is a paper about big data in online advertising. And to set the background, I want to just remind you about how important data could be when we're thinking about showing ads to a pair of eyeballs on a particular website. And I also want to tell you about different types of data that a publisher of the website, let's imagine it's a news site, and an advertiser could potentially use to make sure they're showing the right ads to the right person. The first thing they could do is they could use something called first-party data. And that's data that the website naturally has access to because it knows the kind of content that the consumer has browsed, for example, in the past. So if that news website knows that if ever I see a cruise story, I read it, then perhaps they could use that data to make sure that they show me an ad for an upcoming cruise. Now, second-party data is a little bit more of a narrow category, and this is the category of data where a website has data from a partner and they know exactly who that partner is and what kind of data they're getting. And so a good example of that I came across recently is that Rough Guides, the kind of travel book, shares data, browsing data explicitly with lastminute.com, which is a travel website. And you can imagine why they share data, why it might be useful in working out what ad to show. If someone's just booked a cruise to Italy, then if I'm Rough Guide, I want to show them an ad about my guidebook to Italy. And similarly, if I'm lastminute.com and I found out that someone's been buying guidebooks about Italy, it might be time to get those Italy hotel ads up on my website. The key thing, though, about this kind of data is that this is data where everyone knows what it is and where it's coming from. The last category of data, and this is the data I'm going to be focusing on in this presentation, is something called third-party data. And this is data purchased from a third-party source with the aim of identifying what we call in marketing a customer segment, or a particular kind of customer you might think is interested in your product or service. Now, the actual purchase of this data is extremely complex and subject to a lot of different technologies. I'm going to simplify the terminology slightly in this presentation and just talk about data brokers. And you can think of data brokers as being analogous to a data aggregator that comes and collects all the different data sources from browsing behavior across the web, sometimes offline behavior too, into a file which summarizes all the information that is known about a particular cookie or a particular pair of eyeballs that is browsing the internet. Now, as you can imagine, these data brokers have a lot of data. And as ever with data, just getting pure data in place doesn't actually help that much. You need to make inferences about who the customer is and what they might be interested in if you want to determine what ad to show them. And this paper is going to be all about how good the algorithms are which use this data to try and make inferences about consumers and what kind of ads they might be interested in. So to give you an example of what I mean about this third-party data, I thought we would start with a specific example, and I'm going to show you how to do this with Twitter. Now, why Twitter? Well, simply because it's actually quite straightforward to get access to this kind of data on the Twitter platform about yourself. And also, my gut feeling about the audience of the FTC hearings is many people have a Twitter account. So what you should be doing right now is getting out your mobile, if you're not already playing around with it, and follow along to see how you can find out what data Twitter has about you, which is this kind of third-party data where people or algorithms have made inferences about your profile as a consumer. So what you do is you get out your Twitter profile, and you go and look at settings and privacy. You can see that I have highlighted it right on the left-hand screen right there. And then after that, you go and choose, you go to the privacy and safety screen, and you scroll down to the bottom where you have the opportunity to see your Twitter data. Then on the next screen, I would like you to select the second option, which is this third-party data, which is all about inferred interests that Twitter has from these third parties who've been collating data about your browsing of the internet. Now, if you click on this for me, I'll show you what I see. So you're going to see a whole lot of different things that these third-party data and their algorithms have inferred about you. This is what they've inferred about me. Now, here you can see that they think I have one child. Here I should apologize to my other 3 children. I obviously don't browse enough about you. You can also see that my web browsing patterns has led Twitter to infer that I'm definitely a senior in terms of my age range. I think probably the thing I worry the most about is how it is that these third-party brokers have inferred that I'm a single parent. I think at this point I really do have to apologize to my poor husband. Anyway, the key thing here, for the purposes of this talk, is that you can see demographics, what they've inferred about your demographics, right? Because in general, a pair of eyeballs browsing on a mobile phone or a desktop, there's no real way of sort of telling, exactly what your background demographics are. So these algorithms are going to use the data about your browsing to try and infer what your demographics are from your browsing. And that's going to be the focus of this study. Now, the specific name of the paper I'm going to be talking about, if you want to read it in detail and, go into all the nitty-gritty, is up on SSRM, so you can easily find it there, and it's called How Effective is Black Box Digital Consumer Profiling and Audience Delivery Evidence from Field Studies. I should highlight that this is not work I've done by myself. Instead, I have a wonderful team of co-authors. Nikhil Noman is at the University of Melbourne Business School, and he is an amazing, very junior professor who really cares about this industry and trying to work out what's going on. And Tip Whitfield was actually at one of the large advertising agencies at the time we wrote the paper, and he organized for us to get access to this world to study how well it works. So, huge gratitude to my co-authors. This paper consists of 3 separate studies, and in all these studies we are asking how well does the big data and online advertising ecosystem do in terms of identifying gender and age. Why gender and age? Well, first and most importantly for us, they're things you can actually potentially verify. The second reason we use them is it's actually a very popular form of data that advertisers use for targeting. Indeed, if you look at from industry surveys at least, these age data, gender data tend to be the most broadly used types of data for the targeting of ads. Now, The way we proceeded, as I say, there are 3 studies, and in each study, we actually tried to make the task of identifying whether a particular pair of eyeballs was of a certain gender, a certain age, easier and easier. The first study was the most broad brush. As such, I'll go through it quickly. And what we did there was we went to various ad platforms and said, can you show our ad 100,000 times to men between the ages of 25 and 54? When we gave them this simple mission, there was a large range of success, but we found that they were able to do this on average about 59% of the time when we compared their performance with our benchmark, which was Nielsen data that actually reported the age and gender of the eyeballs that were seeing our ads. Now, in some sense, let's be clear, this is an improvement relative to sheer chance. Sheer chance would be below a third given the makeup of the internet population. So there is an improvement of 184% when we use the big data ecosystem to try and enhance our advertising. I think, though, the big point we try and make in the paper is, yes, it's definitely an improvement. But given that advertisers tend to be paying more than 200% more to show their ads using these data targeting tools, rather than just showing them by chance to everyone, it wasn't quite clear to us that the return on investment was there. Now, that was our first study, and you might say it's somewhat unfair, because it was still relying a lot on humans to have discretionary choices, perhaps, about how they set up the campaign, and that would explain the failure we're seeing. So in our next study, we went to try and take out that human element. So what we did for the next study was we tried to make it easier for data brokers to do this. So we sort of tried to take out the human element. And so in our second study, what we did is we said we have this website. Please, data brokers, tell us who the audience of the website is. So there was no discretion in finding particular eyeballs. You just had to tell us who the eyeballs at the website was. Now, when we did this test with 4 separate data brokers. On average, what was just striking is that they told us, in terms of portion of men, it's 58%, it's 55%, 85%, 63%. I'm not sure what we can say about accuracy here. It doesn't seem great to me. If I got back those numbers, I would still not quite know what the true proportion of men is. What was also striking to me about the study, and you should see it in the paper, is that never mind getting the gender right, they had no idea, when we asked people what the actual number of eyeballs was on these websites. At least there was huge, when I say no idea, what I mean is there was huge variation in the answers we were given, which ranged all the way from 300,000 to 500,000 eyeballs, which is a large difference if you're advertising. So the second study didn't give us much reassurance that we're really getting accurate information here. So what we decided to do in our third study was to just make the task as simple as you could ever possibly imagine. And in this task, what we said to each data broker was, look, you don't have to tell us about a particular website. All you have to do is tell us, do you have data or profile about this particular cookie? And if you do, can you tell us what gender you think this cookie and the set of eyeballs associated with this cookie are? Now, you might be saying, okay, you keep on saying you know really how many, what gender people are, how do you know the truth? And what we did in this study to find out the truth, which, I find quite compelling, is that we used a service named Pure Profile to actually verify what the truth is. And what Pure Profile goes out to do is they actually survey people. And so they go out and say, what gender are you, what age are you, and they give you awards for answering correctly. And so we use that as our source of truth about what the true gender, true age is. And you may, of course, be cynical and say, well, are people answering an online survey really going to be particularly honest? And of course, I'm sure there are some people who are not honest when answering these surveys. However, it's going to be our source of truth, and at least it's what we think of as declared data, or what people want you to think about their age and gender. And so we're going to use that as our measure of the truth. And the question is what did we find when we compared this declared data to what the data brokers were telling us? And you can see here we actually used a lot of different data brokers in this study. And there was a wide range of how many cookies they told us they had information for. And you can see that in the second column. What I want you to look at, though, is the third column. And we actually asked them the specific task of telling us whether or not that cookie was male. And that's going to be our measure of gender accuracy. And the number you see in the third column is the percentage of times they were able to correctly tell us that a cookie was male. And I want you to look at those numbers and also register the fact which I always found the most hilarious about this study and this paper in general, is that if you sort of take the average of accuracy, we're really pretty close to 50%. In other words, these data brokers, this entire big data ecosystem, seems to be able to tell us the gender of a pair of eyeballs correctly half of the time. And if you've ever taken probability theory and you thought about the distribution of men and women, you will see why this is quite funny. The other thing I want you to look at in this table is the second column, which is the number of cookies. And the reason I think this is important for this meeting, I don't usually emphasize it when presenting the paper, but I think it's interesting, is that in some sense you might think of this as a measure of how much data the data broker is really working with, right? Because we asked them, well, how many cookies can you tell us about? And so it seems reasonable to infer that if they can tell us about more cookies, they have more data. Now, the reason this is important is that if you were to try and think about a correlation between the second column and the third column, and look to see is there any relationship between the amount of data that these data brokers appear to have access to and how good they are at telling me gender correctly, there's not, it's not really enough data points to run a regression, but I look at it and stare at it and can just see no numerical correlation really whatsoever. So I think it's important because it suggests there's a surprising lack of correlation between access to data and how well these data brokers are performing in terms of being able to use an algorithm to infer gender. So let's just summarize the findings of this research. So I think the big headline news, and this is going to spill over, I'm sure, into the meetings in 2 weeks' time, is that in general, we often worry about algorithms, big data, AI, and we tend to worry them more from an Orwellian, privacy-intrusive way. However, I'm here to tell you that you might be worried about these algorithms being too accurate. I'm really worried about the fact that they seem to be surprisingly bad at actually getting something very basic like being able to infer gender from browsing behavior. Now, I say it's very straightforward, but when you think about it, maybe there's a reason these algorithms are doing not that but poorly. I mean, I challenge everyone in this room to think about the internet sites you browse and really how informative are they about gender? I can imagine that there are perhaps some particular websites which tell you a lot about gender, maybe, you know, a website devoted to the merits of sanitary products or something like that. I don't think there are probably many men browsing those types of websites. But in general, if you think about the browsing behavior, it's probably not very gendered, and I think that's the sort of overarching problem these algorithms are facing. That they're trying to infer something which maybe is just not inferable given how different from browsing behavior, given how different genders really perform, use the internet. People of the same gender use the internet. You know, the other reason this is going on is actually even more simple. And this is not complete explanation, but it's certainly a partial information. And one of the reasons these algorithms appear to be failing is that we look to see how does that accuracy vary with household size. And we show that as your household gets bigger, I mean, as you have more than one person potentially using a computer or a device, then the accuracy does appear to fall. So, simple explanation, we're trying to infer gender potentially from a computer, which in my case is used by my husband, used by me, used by my kids to watch My Little Pony videos. It's going to be very hard to actually work out what gender a pair of eyeballs are when you don't have just one pair of eyeballs. Now, another point I want to make is not just that this kind of data inference process and the use of algorithms on big data doesn't seem to provide necessarily insights that we might fear it does in terms of how accurate it is. It's just because these are hearings about competition is that you often hear repeated the mantra, the idea that there is a link between access to data and the ability to compete. And especially in a world of algorithms, you can see the argument for that, and that perhaps if I have a larger data set, I can train my algorithm to perform that much better and be able to outcompete my rivals. However, what I saw in this study, at least in this potentially early and nascent stage of this industry, is that the size of data didn't seem to matter that much for really, or really at all that I could see in the data, for how well these data brokers were doing in terms of accuracy. And that suggests perhaps an argument, which I think we'll probably be hearing about in 2 weeks, that really the quality of algorithms are going to be potentially more important. And the quality of people who are able to program these algorithms may end up being more important than the actual size of data that are used to train these algorithms. So with that, I will say thank you so much for listening. Apologies again for not being in attendance. It does look wonderful. And if you have any questions, feel free to email me. Thank you very, very much.
Thank you, Katherine, in absentia. All right, our next speaker is Dennis Hirsch from the Ohio State University Moritz School of Law.
Commissioners and FTC staff, thank you for inviting me here today and giving me the opportunity to present my research at this hearing. I'm going to discuss one of the hearing's principal topics, whether companies can use improved privacy performance for competitive advantage. To address this topic, I need first to slightly reframe it. The question should not just be whether companies can use improved privacy performance to achieve competitive advantage, but whether they can use more responsible data practices writ large to do so, including issues of bias, procedural fairness, and manipulation. Some companies are doing this, and they have a name for this broader project. They call it data ethics. I'm currently leading an Ohio State research project that is studying corporate data ethics, and today I'm going to share with you the preliminary findings from this research. And I will address 4 questions. 1, what is data ethics? 2, why are companies engaging in it? 3, how are companies trying to achieve it? And 4, what does this mean for the FTC's regulatory authorities? I was led to this topic a couple of years ago when at a roundtable discussion I heard the chief privacy officer for a large company say that her department was debating what was ethical to do with data and what was not ethical to do with it. And this surprised me. She was a chief privacy officer. Why wasn't she worrying about compliance with privacy laws? And when I began to hear about other companies engaged in the same activity, I thought it would be interesting to study this phenomenon. I put together a terrific team of colleagues, faculty colleagues, from the schools of business and computer science, philosophy, and sociology. And together, we decided to use 3 methods to try to address this question: a literature review, expert interviews, and a broad survey of companies that use big data analytics. So today I'm going to present our preliminary findings, but first I need to make 2 caveats. 1, we have completed the literature review and we're midway through the interviews, but we have not done our survey as of yet. So this truly is preliminary findings. We're still in the midst of this study. Second, our interviews focus on corporate managers at large companies, so we're not getting a comprehensive view of corporate America, nor necessarily are we getting a fully objective view. That said, I think we have been getting some valuable information that I'll try and share with you today. So, as told to us by those that we interviewed, the story starts with big data analytics and its sister technologies, machine learning and artificial intelligence. Now, it's well known that these technologies can create many benefits, some of which we have heard about already today. But what the companies told us is that they also produce important risks. And they identified 4 types of risks. Risks of privacy violation, such as when Target used predictive analytics to infer from customer purchasing histories whether its female customers were pregnant. Risks of bias, as when Amazon recently discovered that the artificial intelligence application it hoped to use to sort through the thousands of resumes that it received was systematically discriminating against women. And Amazon caught that problem and decided not to use that AI application. Risks of procedural unfairness, as when black box algorithms, which are not subject to explanation or appeal, are used to inform decisions about whether to grant loans or jobs or housing. And risks of exploitation or manipulation, such as when Cambridge Analytica used Facebook users' data to infer the psychological types of those users and target them with political ads that they would find hard to resist. As the companies see it, these potential harms threaten not just the individuals in question, but also the reputation of the companies themselves. And this creates an urgent issue for these companies, which is how to reduce these risks. As one corporate manager put it to us, if data use has much more impact, then you need a governance structure to help manage the impact of that data use to make sure the organization doesn't create more risk for itself. Now, traditionally, companies have mitigated digital risk by complying with privacy laws. But, and this is a key point, big data analytics renders that insufficient, and it does so for 2 main reasons. First of all, the risks that I just mentioned start with privacy, but they go well beyond it to bias, procedural unfairness, and manipulation. So privacy law is not going to be sufficient to address that. Second, privacy law is premised on the idea that, given accurate notice, individuals can make choices about what companies can do with their data. And so, by making such choices, individuals can protect themselves. But big data analytics changes this. It allows companies to take surface data and infer latent information from it. For example, it allows Target to take customer purchasing histories of its female customers and infer whether they are pregnant. Given this ability to infer latent data from surface information, people cannot know what they are really revealing when they decide to hand over the surface information. And as a result, they cannot use notice and choice to protect themselves, at least when it comes to big data analytics, machine learning, and AI. From the company's perspective, this means that if they're going to protect individuals against the risk that these technologies pose, and so protect their own reputations, they have to do more than comply with privacy law. They have to ensure that their practices are also ethical. So here's what one lawyer who advises such companies said to us. Preying on vulnerable populations, treating people unfairly, manipulating people in ways that could harm them. There's some of that stuff that's perfectly legal, but it still may not be a good business decision. I'll throw out the word ethics. It's not the ethical thing to do. Some companies that I work with, they take that stuff very, very seriously. They don't want to do things that feel or could be perceived as unethical. Now some, including some of our colleagues in Europe, see data ethics as an attempt to take Kantian or Aristotelian or other ethical philosophies and use them to govern advanced data practices. But that's not what we saw these companies doing. For them, data ethics is beyond compliance risk mitigation for the big data economy, hence the title of my talk today. So that's what data ethics is. Why do companies seek to achieve it when existing law does not require them to do so? We identified three principal motivations: reputation, employee retention, and the threat of regulation. I've already mentioned reputation, but the companies tell a more nuanced story about it. There's reputation among customers and users. This is essential to preserve the bonds of trust on which the flow of personal data depends. As one company manager said to us, if you act ethically and ensure that data use is ethical and you're fully accountable for that, then your brand is trustworthy. That's what we're all trying to achieve. Then there's reputation among regulators and advocates, and a poor reputation among these constituencies can lead to increased scrutiny and litigation. And finally, and this is the one that surprised us a bit, there's reputation among your business partners. A lawyer for one technology company saw this as the most important aspect, since other businesses are able to do due diligence in ways that individuals cannot, and will work, are able to do due diligence in ways that individuals cannot and will not work with companies that don't pass muster. Employee retention was a third major driver. Tech companies in particular expressed that competition for young engineers is fierce and is critical to corporate success, and that companies need to align their actions with these young people's values in order to retain them. The third driver we saw was the threat of regulation. Some companies believed that if they took proactive steps to act responsibly, they would reduce the chance of direct regulation, data ethics as a way to preempt direct regulation. Others, with an eye on the GDPR and other rules, saw data ethics not so much as a way to avoid regulation, but as a way to prepare for it. They felt that if they aligned their products and systems in advance, they would be able to deal with such regulations more effectively and at less cost than their competitors. So with each of these drivers, reputation, employee retention, threat of regulation, companies are seeking a form of competitive advantage. And thus our research suggests that corporate data ethics represents a new form of competition in the algorithmic society, one that goes beyond just competing on privacy attributes. One leading privacy professional put it this way: I think that for some of these companies, they've actually seen data stewardship as a competitive differentiator, and that they are more trustworthy and people are more likely to do business with them and therefore pay higher prices. I should add that several interviewees expressed that their company's values were also very important in driving their data ethics initiatives, and that was particularly true where a CEO or a founder had instilled those values particularly strongly. So that can also be a motivator. Now, we've looked at the what and the why of data ethics. The next question is the how. Here, it's helpful to divide this into two areas, process and substance. In terms of process, one of the really interesting developments that we found is the transformation of the privacy officer role into a role that included not only privacy, but also issues of bias and procedural unfairness and manipulation. Reflecting this, some companies changed the title of the position to include the word ethics or data ethics in it. This is a new development that has just arisen, we think, within the last year. But it could soon be common to have a chief data ethics officer to go along with your CIO or your CISO or your CPO. Another interesting development was the creation of new committees to advise the companies on ethics. Some created internal committees, sometimes called an ethics review committee, to review data analytics projects that raised ethical risks. Such committees could include representatives from legal, privacy, security, engineering, and the affected business unit. And we saw instances in which such a committee advised against certain projects and the companies turned down significant contracts on this basis. Other companies ran their ethical questions by external committees, sometimes called external advisory boards, that might include privacy and consumer advocates or members of civil rights and civil liberties groups or academics. In contrast to the internal boards, these served in purely an advisory role and helped to sensitize the company to stakeholder concerns. There was quite a bit of variety in the way the companies managed in this area. For example, they differed on the scope of their ethics management activities. Some focused on the company's own internal research with customers, personal information. Others expanded the scope to include not only their own activities, but also those of data suppliers, customers, and business partners. Anyone whose ethical lapses could be linked to them. I practiced and taught environmental law before I turned to data and privacy, and these programs reminded me of the way in which some companies audit the environmental performance of their entire supply chain, a process they call greening the supply chain. Companies also diverged in terms of management structures and reporting systems. Some localized the ethics function in a single person who had a direct line of communication to the C-suite or the CEO. Others had a far more elaborate process in which all data projects had to be submitted for review. As we understood it, the first seemed to produce faster decisions, the second, better quality decisions. So there's a trade-off here. Turning from process to substance, we sought to identify the standards that companies employ to assess whether a given data analytics project is ethical or not. The literature suggests that companies employ or should employ formal principles grounded in philosophies of ethics. For example, the Software and Information Industry Association that Mark McCarthy works with, and he was here today, they draw on such ethical traditions and published a report that articulated 4 core principles: rights, justice, welfare, and virtue that companies should follow when making decisions about ethics. The companies we talked to were not using any such formal framework. What we saw was far more intuitive. One manager referred to the, quote, fairness check, which the manager described as, would my mother think this is okay? Would I want this to happen to my kid? Do I feel good about this personally? Another employs the ear test, saying the ear test simply means to me, does that sound right? Does that sound like a bad idea? Do the words coming out of your mouth make sense from both the legal, ethical, and business standpoint? So these companies are using much more intuitive, expectation-based standards rather than formal, philosophical ones. Such standards fit with the idea, mentioned earlier, that companies are seeking not to implement an ethical philosophy, but rather to engage in beyond compliance risk mitigation. In this sense, data ethics is a new dimension of corporate social responsibility. It is CSR for the data-driven business. Responsibility, appropriateness, trustworthiness, fairness, these seem to be the currency of data ethics. Now, these can be difficult concepts to operationalize, and some companies seem to really struggle with drawing these lines. The hardest question seems to be how to get the balance right, how to determine, considering the potential benefits and risks, what is fair and what is not. As one attorney said to us, when do these lines get crossed? That's not always obvious. What does all this mean for a regulator like the FTC? Well, when you step back from what we've learned so far, you really see two things. You see a pretty clear consensus among the larger, more sophisticated companies at least, that it's important to go beyond compliance and seek to mitigate the risks that big data analytics can pose. So there's quite a bit of agreement on the what and the why. But the how question is much more murky. Companies are experimenting with many management processes and trying to figure out which will be more effective. And there's some confusion as to how to draw the line between responsible and irresponsible behaviors. I mentioned that I came to privacy from the environmental field. And this situation reminds me in some ways of that which environmental regulators faced when companies started to compete seriously in terms of their environmental performance, which is known as green business. One thing that environmental regulators did, and the FTC could do, is to collect and share best practices in this area as a way of getting more companies to adopt them. Another would be to adopt a leadership program that recognizes companies that are going above and beyond in this area, and so add to the reputational value they derive from doing so. A third would be to define some standards in this area. Now, I would caution against doing this with respect to process. There seems to be a lot of positive experimentation going on, and regulators may want to let that play out before determining that one approach is preferable to another. But it may be worth giving this further thought with respect to drawing the substantive lines. Were a regulator to provide some guidance, that could give companies a clearer sense of what the regulator's expectations are and help them to make some of the tough calls. It could also set a floor that all companies have to pay attention to. Right now, we're seeing the larger, more sophisticated companies start to manage data ethics. But other companies that are not paying attention to these issues could do some really bad things that could not only hurt people, but could also turn the public against data analytics, machine learning, and AI more generally. As one attorney said to us, in this fast-paced world where there's, huge financial opportunity for companies, you can easily see scenarios where someone's going to, quite frankly, bring down the whole house of cards by doing something just totally unethical and totally unfair and screw it for the rest of the industry. Seen in this light, a regulator's decision to set a floor for fair and ethical behavior could potentially support the efforts of the current leaders while still giving them room to distinguish themselves. If the FTC wanted to develop such substantive guidelines, rules of the road for predictive analytics, it seems to me that it has the power to do so. The line that companies are trying to draw is between advanced analytics that is appropriate and that which is inappropriate, between that which is responsible and that which is irresponsible, between that which is fair and that which is unfair. Section 5 of the FTC Act, of course, gives the Commission the power to define unfair business acts or practices, and so to draw these lines. The FTC's Unfairness Authority has some useful features in this regard. Unfairness is an open and flexible standard intended to adapt to emerging and changing technologies and business models. It requires the Commission to balance benefits and costs, which is important in an area like big data analytics that offers many benefits as well as many risks. And unfairness is intended precisely for those situations in which individuals cannot protect themselves, where, in the language of Section 5N, the injuries are not reasonably avoidable by the consumers themselves. That is where we are with respect to advanced analytics. Individuals cannot understand how these technologies work, and so cannot use traditional privacy protections, notice and choice, to protect themselves. Some companies are moving proactively to protect them. The FTC could potentially use its own unfairness authority to support this corporate data ethics effort. Thank you for letting me share my thoughts and research with you today.
All right, next we have Jane Bambauer from Arizona Rogers College of Law. There we go. Thank you.
Have I advanced the slides? How do I advance this? It's this? Okay, and it's the main, okay. Okay, thanks for having me. I want to do something that will give me a little information and give you a chance to wake up. So please stand up for a second if you can, if you're willing and able. Okay, and then if you're not a lawyer, sit back down. I just want to get a sense of what this audience, if you're not a lawyer, okay, so that's about half of you. And then for those who are still standing, if you don't know what the case Sorrell versus IMS is about, sit down. Oh, good. Okay, this is going to be valuable. Thank you. Okay. All right. So my goal with this talk is to provide a descriptive account of what's going on in First Amendment law and the ways that it might actually limit some of what the FTC may want to do, even if it has set its sights on what it thinks is the best policy. I'm going to be as descriptive as I can without letting my own policy preferences kind of shape that description, because I'll have a chance tomorrow to talk again about what I think about best policy. So I'm going to do my best just to be sort of honest about what's going on in the courts, but the courts are being quite active in this sphere, and you all should pay attention. Okay, so before I dive in, though, let me tell you a little bit about what I'm not going to talk about. I won't talk about restrictions on commercial speech. The commercial speech doctrine, it's a little bit misleading. It's actually a narrow category that covers just marketing messages and advertising. So some people sometimes think that commercial speech, which gives lesser protection to commercial, it's a doctrine that gives lesser protection, that would apply anytime someone's selling something to someone else, or anytime that somebody has a commercially motivated purpose to say something, and that's not accurate. So, like, books are sold, right? And obviously books receive full protection. So commercial speech doctrine is narrow, and it's related to potential privacy regulation because privacy laws often have as at least one of their end goals to affect how marketers can craft messages. So in that sense, it may be related. Also, if companies are giving false assurances, either explicitly or implicitly to consumers, that their privacy is protected when it's really not, that's related to the commercial speech doctrine. The commercial speech doctrine doesn't allow any protection, any First Amendment protection to false and misleading commercial claims. And that's interesting, and what it means to be misleading, especially when a company is committing an omission when they're not saying anything, is still an open question about whether that is sufficiently misleading to remove the company from the ambit of First Amendment protection. And there are some papers, including one that I've written recently, that kind of tackle this question of who gets to decide what it is to be false or misleading. And by the way, I'm sorry, I mangled Rebecca Tushnet's article. Hers is actually called, "It Depends on What the Meaning of False Is." I was writing these slides late, but we engage in a little bit of a debate about who should decide and whether the courts need to be involved. And it's interesting, but I'm not going to talk about it today. The other interesting thing that's out of scope for today is the compelled speech doctrine. So that's related to privacy because regulators might be interested in something like just-in-time privacy disclosures that make clear notice about how a company is going to use your data, and we may be interested in forcing companies to actually provide these disclosures. And the Supreme Court has given its blessing to mandated disclosures that are purely factual and uncontroversial information. So maybe like nutrition labels on food items. I think most people tend to think of that as purely factual. But it's not clear whether a privacy policy would be, or mandated privacy policies would be purely factual and uncontroversial. And I talk about this at some length in another article, so if you're interested in this topic, you can see my article that tries to map out what courts, especially lower courts, have done to decide whether a factual mandated disclosure is ideological and therefore subject to constitutional review, or merely informational and not subject to any amount of review. Interesting stuff, but we don't have time because I want to get straight to the core of what almost every privacy law is going to wind up potentially coming into conflict with, and that's a restriction on non-commercial speech. So this usually will happen in the course of privacy regulation through one of two ways. Either a law will put a limit on the transfer of personal data between, say, one company and another, or it will put a limit on the initial collection, or maybe even the initial inference, right, based on already collected data about a person. And, you know, almost every privacy law, if you think about the FIPS, the Fair Information Practice Principles, they usually involve giving the data subject some amount of control over these two activities. And that control necessarily puts a limit on these data transfers or the data collection. So much of what I'm going to say, but not all of it, is lifted from an earlier article I did called "Is Data Speech?" asking, well, okay, is the First Amendment relevant here? Do we need to worry about potential constitutional review when we're dealing with data privacy? So let's start with the, oh, that's right. To ground the discussion, I'd like to have you think in the back of your head thinking about the California Consumer Privacy Act, because I think that's, for many consumers, that seems to be a model privacy law. It seems to tap into what many people want, or at least believe that they want. And the most important rights that are relevant for my discussion is that it gives Californians the right to say no. This is taken from the website of the designers of the law. It gives Californians the right to say no to the sale of personal information. It also, by the way, gives them the right to demand the deletion of personal data unless it's required for the service of the company. And just like with the GDPR, if a Californian does opt out of data sale, for example, they still must be given service on the same terms as somebody who is not opted out. But unlike the GDPR, it's an opt-out regime rather than an opt-in regime. Okay, so as I tell you about some of the case law, work with this hypo. Law professors love hypo, so ask yourself, okay, how does this affect the constitutionality of California's recently adopted but not yet implemented law? Okay, I'm going to start with data transmissions. These little stick figures are meant to be like companies or people who are selling data, and that red thing is data, right? Okay, so the first question that free speech lawyers generally ask is, well, is the First Amendment even relevant here? Does it cover this kind of activity? Would we call this activity speech? And I'm starting with this rather than the initial data collection, even though it usually comes later, because I think this question is actually much easier to answer. I think courts are converging on a clear, yes, this is speech, this is covered. So the Supreme Court itself in earlier cases had found that really dry information like credit reports or beer ingredients are speech. Really anything that communicates from one person or entity to another is speech. The lower courts, too, found that even in the context of privacy laws, that the privacy laws may survive scrutiny, but that scrutiny must be used. Then the case of Sorrell versus IMS, which most of you don't know about, which delights me because I can tell you about it, really made this even more clear. So this was a case from 2011 or 2012 involving a Vermont statute that banned the sale of prescription data to pharmaceutical companies if the pharmaceutical company was going to use the data to fine-tune the detailing, basically the marketing, messages that it made for doctors. So the data did not have the identities of the patients, but the data does have identities of the doctors. So you can see it was justified partly on privacy grounds and partly on public health grounds. And as a privacy law, this seems rather narrow, but you can see how the implications might affect other types of broader privacy laws. Because if you think of doctors as standing in for consumers here, The law was trying to give doctors the opportunity, they could opt in to this types of marketing messages based on their data if they wanted to, but it was trying to give them some control such that behavioral advertisers basically wouldn't have a lot of detail about their habits. So the Supreme Court, by the way, some commenters and even the circuit courts that were hearing similar cases before Sorrell was decided, thought that this type of law would fall outside the First Amendment protection completely because data that's just like sitting in a server and that's just sold for these types of purposes is no different from any other product. I think the First Circuit even said it's like the equivalent of beef jerky, selling beef jerky. The Supreme Court definitely rejected that. So in an opinion by Justice Kennedy, he begins the analysis by saying this court has held that the creation and dissemination of information are speech within the meaning of the First Amendment. Facts, after all, are the beginning point of much of the speech that is essential to advance human knowledge and to conduct human affairs. In the end, it got a little confusing because the case was ultimately decided on grounds of viewpoint discrimination, because what at least Justice Kennedy thought was the biggest offense about this law was that it prevented only pharmaceutical companies from using this type of tool to craft their messages to try to persuade doctors to do something. And it left open any other speaker who was trying to persuade a doctor to do anything else. It left access to the data open to them. So the case was ultimately decided on viewpoint discrimination grounds, but that dicta that came earlier seems pretty compelling, and especially because it's consistent with what the Supreme Court has said, or at least assumed in the past, that if something communicates, it's speech, unless it's in some very narrow special category like fraud, defamation, and a few others, incitement. Okay, well, all right, so a data privacy law might have to undergo scrutiny, or probably will have to undergo scrutiny. What level of scrutiny is going to apply? This question's much harder to answer. So a case called Dun & Bradstreet versus Green Moss Builders involved a credit report that was wrong, importantly. And in a defamation action, the Supreme Court decided that only intermediate scrutiny, a lower level of protection applies in this defamation case because credit reports that are given to just a couple potential lenders are matters of purely private concern. So you can see a line with this case emerging, that separates speech of public concern or general concern from speech of purely private concern. Dun & Bradstreet could have been limited to just defamation cases, but it has not been limited to that. So the Supreme Court itself has cited to Dun & Bradstreet in cases that have nothing to do with privacy for the proposition that speech of purely private concern is not as protected. So you might think, okay, well then privacy laws are going to have to only undergo an intermediate scrutiny, but more recently in Reed versus Town of Gilbert, the Supreme Court decided that strict scrutiny must apply to any law that on its face makes a distinction of any sort based on the content of that communication. And if you think about the California Consumer Privacy Act or many of the regulations that the FTC in the past at least has considered, or that is included in the GDPR, the linchpin for regulation is personal information, right? And it's defined in certain ways, and that's all about the content of the data. So if Reed is applied faithfully, it's not clear that courts will be able to do this, but if we're serious about Reed, then it looks like strict scrutiny would apply. At this point, I don't have a confident prediction about which level of scrutiny would apply. But going back to Sorrell for a minute, in the end, when the First Amendment is applied to some sort of privacy law, it's possible that courts could distinguish cases like Sorrell, because even in the opinion itself, Justice Kennedy said, well, perhaps the state could have addressed physician confidentiality or privacy through a more coherent policy. Now, some might object to the idea that the Vermont law was incoherent, because if it was targeting kind of the most obnoxious form of data sale, then maybe the legislature was right to just pinpoint that particular form of data sale and leave all others, untampered. But if we take this seriously, then perhaps something like the California statute is more likely to survive because it's broad, because it's so comprehensive. I have some doubts, though, or rather, that there are at least a few reasons to think that the government would have to prepare strong arguments and a good base of evidence in order to defend even especially a broad privacy law that prohibits the transmission of data. For one thing, just in the past, even since the 1960s, the Supreme Court has listened to cases that involve the clash between privacy and the First Amendment, usually in the context of some sort of magazine publication, public publication, and has found that the privacy interests are not compelling enough to outweigh the general interest in speech. The other thing, though, I'm going to skip this for a second in the interest of time. The other thing is there's been a series of Supreme Court cases, none of them directly related to privacy, but each of them showing that the Supreme Court is extremely skeptical now of any attempt by the government to justify what it's doing based on just kind of common sense ideas of harms or risks. So Brown versus Entertainment Merchants Association, for example, was a case that involved a California ban on the sale of violent video games to minors unless the minors had their parents' consent. And the Supreme Court found that the law was unconstitutional, even though the state brought a mountain of social science evidence with it, because the Supreme Court, rightly in my view, but obviously reasonable minds could differ, but the Supreme Court thought that social science evidence was actually quite bad. It was poorly done. So the courts are showing an increasing willingness to even look at probe the quality of the evidence that the government has and offers in order to justify their restrictions on speech. Let me spend just a minute talking about the data collection side of things. So for a long time, so this guy is using his cell phone, I guess, to record someone. So for a long time, the assumption was data collection is not protected by the First Amendment, even though subsequent publication of that information would be. So in a case called Dietman versus Time, the Ninth Circuit decided that Time magazine, they snuck a couple journalists into a quack's office, like a guy who just was waving wands and turning knobs and pretending to cure diseases, and they did an expose on him, and the court found that the actual publication was fully protected by the First Amendment. They couldn't be sued for public disclosure of private facts, a relevant tort. But the sneaking in of technology to surreptitiously record what was happening, the secret photographs, that was completely unprotected, the court said. And the Supreme Court, in a case Bartnicki versus Vopper, said something similar, that downstream publications are protected, but actually getting access to information or knowledge is unprotected conduct. It's just conduct. It's not speech. That always seemed weird to me, because if you think about the reason to limit data collection, it usually has something to do either with knowledge creation by the person who's collecting the data, or with downstream communications that person intends to have. And so if we think of both knowledge and communicating as being core to the First Amendment's goals, then why should limitations on collecting information in the first place get a free pass and not get any scrutiny at all? Well, sure enough, in the last couple years, this is a really recent development, but there have been right to record cases that are starting to chip away at this distinction. The first set of cases had to do with recording the police doing in public. And now every circuit that's heard these types of cases has decided that there is a First Amendment right to record police. The Seventh Circuit has gone further and said there's a right to record anytime you're in public. And then also, there have been successful First Amendment challenges to so-called ag-gag laws that prohibit people from secretly recording at farms, at commercial farms. And so that too is suggesting that even surreptitious recording, even in private spaces, has been getting increasing First Amendment attention. All right, so I raise all of these legal limits not to discourage the FTC in any way from crafting responsible privacy policy, but rather to, in a way, to applaud you for doing these types of hearings, because it's tempting to do something like what I think the FDA had done, regrettably, a few years ago, and to just kind of to plan to defend your policy later in court. But it will save you a lot of headache and heartache if you have a good evidence base and a good theory of what type of interest in seclusion or confidentiality you're actually trying to preserve in order to come prepared for First Amendment defense. The other option, of course, and this has come up already, is to actually prohibit disfavored uses that really are conduct rather than speech. So that's an option as well, and then you don't have to defend against the First Amendment at all. All right, thank you very much.
All right, we have Heidi Schwartz as our next speaker.
Do I just, this is, okay. There are actually surprisingly a lot of water bottles still up here that are now falling. Okay, so I'm Heidi Schwartz. I'm the acting deputy director of the Bureau of Competition at the FTC. First, a disclaimer, these remarks are my own. They're not those of any particular commissioner or the commission as a whole. I also want to say that I'm looking at this from the competition side of the FTC. I believe my colleagues in consumer protection are talking on other panels, so this is from the competition side. When people talk about data, they usually talk about the 4 V's of big data. Volume, how much data are we talking about? Velocity, how much data is coming through and how quickly. And for us, that means how much does it have to be updated and what's the flow. Variety, what are the different forms of data and are they complements or substitutes? And veracity, how accurate or inaccurate is the data? In the FTC context, when we think about data markets, the 4 V's are implicitly part of our considerations. And we look at how big data is being used. Is it a product? Is it an input? Is it a tool? Often it is 2 or 3 of these things. And of course, we look at whether the data is unique or broadly available. This is particularly important because it affects entry and expansion options of other firms in the market. So how do these cases often look to us, and how do they come to us? In the instance of 2 database companies merging, they often sell data products. And 2 of the older examples that I have are these type of cases where it's 2 merging databases. If we go back to 2001, the FTC challenged the consummated merger of Hearst Trust and First Databank that involved the merger of 2 competing providers of integral data, drug data files. And then if you go forward to 2010, the FTC challenged Dun & Bradstreet's acquisition of QED, which was a division of Scholastic that involved K-12 educational marketing data, such as contact demographic and other key information related to teachers, administrators, schools, and school districts. So if you look back, we have a long history of where the database and is the product, and we are challenging those mergers. In some of the more recent cases I will discuss in this presentation, data was a key input. It wasn't the actual product itself, but it was integral and essential to the product. And in many cases, we'll look at data is also being used as a tool, and it can be a tool and a product, a tool and a key input. And in cases involving data markets, we will look at how the data is being used and whether it is a key differentiator as well as other key dynamics. In these data cases, entry conditions are often critical. What other firms, if any, could replicate the competition lost in the relevant market, discussing how data may facilitate or create impediments to that entry. As I've alluded to, the FTC has a long history of cases involving data markets. The history goes back to at least 1996, when the FTC filed an administrative complaint against ADP's 1995 acquisition of Auto Info's assets, charging that the acquisition would raise prices and reduce the quality of service and innovation to automobile salvage yard information management industry. So these are key tools that the automobile salvage yard used, and as well as insurers used. The parties each maintained interchanges, which were essentially databases of numbering systems for auto parts and parts assembled through that insurers and salvage yards use as sort of an index to determine interchangeability of parts. The parties also had significant software assets, an electronic communication system that allowed auto salvage yards to actually buy the parts and see automatically and quickly, sort of through a central database, what the inventory was at the other yards that subscribed. In the end, the case settled with the divestiture of the former Auto Info's assets as an ongoing business, which included granting the acquirer an unrestricted license to the interchange, which by that time had become sort of the default industry standard for a cross-numbering index for parts. Moving on to 2014, CoreLogic and DataQuick, the data as a product. This was a merger that the FTC challenged in March. In March 2014, CoreLogic agreed to settle FTC charges that its acquisition of DataQuick would likely substantially lessen competition in the market for national assessor and recorder bulk data. So what is national assessor and recorder bulk data? It's current and historical data on properties pulled from local public records, like deeds, mortgages, etc., that is aggregated and standardized in bulk format. It includes information about ownership, value, and other characteristics of properties. So it's public information, but it's not standardized, it's not easy to collect, and you need both historical and going forward. Customers of this data, so customers of the companies, use the data in various proprietary programs for risk and fraud management tools, valuation models, and a lot of other uses. The complaint alleged that the merger would eliminate one of the three providers of national assessor and recorder bulk data, increasing the risk of coordination between the remaining two firms and the risk that CoreLogic could unilaterally raise prices. In terms of the market structure, there were regional assessor and recorder bulk data firms, but the commission looked at that and saw that they could not combine or reposition to actually compete in the national assessor and recorder bulk data market. They would have gaps, they would not be standardized, and there were other issues there. At the time of the merger, CoreLogic licensed its current and go-forward data to DataQuick, which DataQuick was permitted to relicense in bulk. So in other words, DataQuick was actually kind of dependent on CoreLogic for the data. DataQuick used the licensed data along with its own historical data to compete head-to-head with CoreLogic. Importantly, DataQuick was unique in its ability to credibly threaten to enter because it already had historical data. It had acquired a company years before that CoreLogic was willing to license to them. Because it acquired that historical data, CoreLogic viewed it as a potential entrant, and therefore it sort of got economies of scale and scope by licensing to DataQuick, and it felt that DataQuick would be in there anyway. If it didn't, because it had the historical data, it could have amassed the sort of ongoing data itself. So it was willing to license years ago to DataQuick after it had acquired an historical database. That said, it was very unlikely that anyone else could enter because the breadth of historical data they would need to be gathered and the ability to continue gathering that data would be prohibitive. So no one else was going to have that unique ability to have the historical data. The remedy that we constructed was designed to allow a company called RealtyTrack to step into the shoes of DataQuick as CoreLogic's licensee. The order required CoreLogic to irrevocably license to RealtyTrack equivalent data to what DataQuick offered to its customers and update the bulk data for 5 years. That was in design. The 5 years were designed RealtyTrack to compete with CoreLogic while developing its own ability to collect national bulk data. RealtyQuick, as we implemented this, RealtyTrack realized that CoreLogic was not providing the entire data set that DataQuick had access to and raised concerns that led to a commission investigation. Just recently, in March of 2018, the commission modified the order after finding that CoreLogic had not provided RealtyTrack with all the required data on a timely basis. The modification adds 3 years to the original term of the order and specifically spells out the quality, service levels, and data transfer requirements. Takeaways from the CoreLogic data quick merger. Here, the data was the product being sold, and the breadth, detail, and the complexity of the data created barriers to entry. This matter highlighted the complexities involved in attempting to remedy a lessening of competition when data is the product. You would think it's a database, it's not that hard to transfer, but here, the buyer's due diligence may not necessarily, what we learned is buyer's due diligence may not necessarily uncover missing or necessary data in a timely fashion. And the commission had difficulty initially identifying the exact universe of data required to effectively compete, and required additional work by the buyer, the monitor, and the commission to determine what data was missing, how it needed to be delivered, and how it needed to be continuously updated. Verisk EagleView, data as an input. So here, it wasn't, in 2014, the commission issued an administrative complaint seeking to block Verisk's proposed acquisition of EagleView in the growing market for rooftop aerial services. Verisk's subsidiary competed with EagleView to provide software that, when combined with the library of aerial images of rooftops, allowed insurance adjusters to effectively and efficiently and safely measure roofs. As you can imagine, the old-fashioned way they used to do it was adjusters would actually used to get up on the roofs and do the measurements. That has issues with both accuracy and also significant safety issues. The measurements in turn allowed insurers to estimate the cost of repair or replacement of insured roofs. Verisk also owned the software that customers used to make other measurements to estimate damage claims. The commission alleged a product market of rooftop aerial measurement products, or ramps, for insurance purposes. Interestingly, for insurance purposes is key in terms of it was actually a targeted customer market, because the product was used both by insurers and by adjusters and contractors. But for insurance, although the software products function somewhat differently, both required the same input, the aerial images, and to carry out the same functions. That said, insurance companies, the commission judged that insurance companies had different needs and requirements than other customers like contractors. And contractors generally felt that they could, switch to manual measurements. Insurers could not. As I noted, the product here is not the data itself, but the data was a key input to the product. In terms of the market structure, the merger of these two was judged to create a virtual monopoly. EagleView was the first to develop software using aerial images, and these are actually particular types of aerial images. It's not just any old aerial image. It had to have certain angles, certain types of views, i.e. leafless. Like this is, in another few weeks, this will be a good time of year to have aerial images, because you can actually see the roof in the measurements. It's not a particularly pretty photo, but it does make a difference in terms of aerial photos. And at the time, EagleView had the first mover advantage of amassing a market share of 90%. It also had by far the largest aerial image library. Verisk was a relatively new entrant, entering just 2 years before the proposed acquisition, but it quickly amassed, a not insignificant market share, substantially more than any other competitor, and it was offering discounts and direct competition to Verisk, to EagleView. The commission alleged that if the transaction was consummated, discounts would disappear and prices would rise. An important aspect of Verisk and EagleView's competition is their ability to obtain the aerial images that are up to date, so measurements reflected those of current structures, high quality, because it allowed adjusters to identify attributes of the insured property, and it also had to be available on a national scale. National insurers wanted to be able to use the software for all of their insured products, and it wasn't worth it to them to sort of have different providers in different areas of the country. EagleView, as I said, had the most extensive library of aerial images. Importantly, insurers also required the ramps integrate seamlessly with claims estimation software, and because Verisk was the leading provider of claims estimation software generally, it was able to overcome and was uniquely positioned to be able to overcome a more limited library of aerial images. by capitalizing on its relationship with the insurers and the fact that it had the best and most sort of commonly used software. Verisk and EagleView abandoned the transaction after the commission issued the complaint, so the case never was considered by a court. But what the commission considered in the complaint provides us with some insights. In this case, while data was not the product defined in the product market, it was an essential input into the product and affected a firm's ability to compete and enter the market. The commission considered the incentives to increase the quality and volume of data as a loss of innovation. So that was also an issue. Now I'm going to talk a little bit about Ccc Mitchell, which was a challenged merger in 2009 that the FTC challenged. Full disclosure, I actually was in private practice at the time and was working on behalf of Mitchell, but I am basing this entirely on public information. Okay, so access to data as an entry barrier. It was a key input, not the actual product itself. There were two products at issue. One was Estimatics, which is a database used to generate repair estimates for automobiles. This wasn't particularly the product used for sort of specialized trucks or other things like that. And total loss valuation systems, which were used to determine when a vehicle is totaled and even more importantly, the value of it. At the time of the merger, the big three, which were Ccc, Auditex, and Mitchell in that order, had about 99% of the Estimatics market. There were two French competitors, most importantly that we'll talk about later is WebEst. And for TLV, the big three accounted for 90% of the market. Mitchell had entered later and had a significantly smaller share. There were two types of customers, insurers and repair facilities for Estimatics, and primarily insurers for TLV. Okay. Database dynamics. So the primary components of Estimatics and TLV were the databases themselves and the software. And so how did these firms get the databases? CCC had obtained an exclusive license to the Hearst publishing database called Motor in 1998. Auditex and Mitchell each had sort of grown their own system painstakingly over years. And part of the reason why Mitchell was smaller is it had taken them many years to create their own database, and they did so. WebEst licensed Mitchell's database, but under very restrictive conditions. It was not allowed to sell to any of the top 50 insurers. It could not have a communicating product, which meant that basically it could only sell to independent repair stations, not those that were part of a particular repair network. And it could not integrate with other third-party apps, vendors, things that other insurers and other service stations used. So the proposed fix. CCC offered to do two things in terms of making a database available. One, it offered to relinquish exclusive rights to the Hearst Motor database. That meant that any new entrant could license that database. And it was fully updated and would continue to be fully updated because Hearst kept that database updated and it was licensed. And Mitchell would remove restrictions on WebEst and continue that database license. So therefore, there would be both WebEst with the Mitchell database and CCC offering to sort of relinquish its exclusive. Anyone else could have access to the Hearst database. Auditex would continue with its proprietary owned database. The judge found the availability of databases would reduce the most critical barrier to entry, but she still found that there was significant other barriers. One, customers were sticky, particularly the insurance customers that were critical to success. And you needed to establish a track record and have a lot of sort of support capabilities. Scale mattered. The judge did note that the WebEst, which is led by a guy named Eric Seidel, had been in the industry for a while, had good experience, had significantly grown his addressable market share, which had been really independent service stations. But he only had 10 to 15 employees. And so the sort of growth curve was going to be too long and too steep. It just wouldn't be sufficient entry in the time required. By comparison to WebEst, 10 to 15 employees, Ccc Mitchell, after they combined, would have had about 2,000 employees. Interestingly, the judge actually decided this case as a coordinated effects case and not as unilateral effects case. she had found some issues with the FTC's experts' unilateral effects analysis. So it was a PI hearing, not a full trial on the merits, but she decided that the coordinated effects were too likely. Okay. Microsoft, LinkedIn, and this is the last case I'm going to discuss before talking about a few takeaways. So Microsoft is obviously strong in operating systems for personal computers and productivity software. LinkedIn is a professional social network that a lot of us probably use. The U.S. investigated but not to take any action. The EC concluded that the merger did not raise competitive concerns related to data, but it did find, so what it looked at, and these are some of the answers to questions that we often ask, is the data readily available from other sources or similar data? And yes, we found that the EC found that other sources existed for that data. They also found that the companies hadn't particularly provided that data and made it available on the market before, so there wasn't really going to be a change post-merger. And they had relatively low shares in the market that the EC was concerned about. The EC did require several commitments, and those are just up there. Those primarily had to do with interoperability and ensuring that others could be competitive on the professional social networks. You can see those there. I'm not going to read through them. But they did not have to do with particularly the data possessed by the companies. Okay. Takeaways, and I'm going to try and end early. So takeaways, competition analysis, because I'm sure you guys have had a long day and appreciate you all staying. Current antitrust analysis accounts for how firms compete using data. Data markets and sets are highly differentiated. Each investigation looks very closely at the specific facts of the case. We recognize that data markets are dynamic. Quality and innovation effects may be particularly important. They also may be harder to measure than price effects. How data enables or hinders entry or expansion also may be particularly important. Remedies. In cases that involve data, just like in any other cases, we have a preference for structural remedies. We've seen a number of cases that I discussed where we look to divest or clone a database versus a license. Sometimes we'll allow a license. It depends on the specific facts of the case. There's the issues related to how they're going to continue to obtain the data and keep a new data flow that's accurate and is expansive. And what we found in our database cases and what we've learned is there's a lot of complexity to how the data is stored, how it is updated, how it is kept, and how it is provided to customers. And it seems simple, but there's actually more due diligence that needs to be done, not just by buyers of potential assets, but by the commission and others during that process. There are often IP and copyright issues, and while they're not favored, behavioral conditions may be needed. In some of the cases that I talked about, for example, CoreLogic, there were commitments that we required related to allowing customers to break contracts so that the new firm could have contracts going forward over a certain period of time. So sometimes we have to overcome customers' reluctance, and in some cases, ability to switch. We need to give them ability to switch to have the new entrant actually be able to have those customers. There are other types of behavioral conditions, including some support over a transition period that we will look at as well. But as noted, structural is always preferred, including in data cases. Thank you, guys.
Thanks, Heidi.